I don't know if you have any other apologies or for late arrivals. Ms. Mark, anybody?
No, sir.
All right, so we go with that. We go with that. All right, so as we know, we're winding down to Christmas period, so this will be our last meeting, but we still have quite a bit of work to do. We have the OUR here again today to present, and we will take the OUR recommendations starting with section 18.2, and then we will go to section 22.2, and then section 23 to 60. So it is unlikely that we will be able to complete the OUR presentation today, but we'll go as far as possible. We also have the section 2 interpretation, definition, net billing and power purchase agreement, and also all general recommendations. So there are 2 dates that will be proposed at the end of the meeting for January. And hopefully if we can confirm those 2 dates, then it means that we will hopefully be able to complete the OUR and move on. So this may delay us a bit, but it's important that we can carry through with this process of the presentations from the OUR. We have also the review and confirmation of minutes, both for October 28th and November 11th. I don't know if members have gotten an opportunity to go through those 2 sets of minutes, and we can take them now, or we can defer them to the later on in the meeting towards the end under any other business. I know the 28th, I think Minister Member Paul had asked for that one to be deferred. So members, in terms of the minutes review and confirmation for the 28th of October and November 11th, can we take them now, or you want to defer them till later? All right.
I was going to suggest we defer them till later so we can go straight into the OUR and release them and then take a look at the after maybe.
All right, we'll do that. So we will just remind me to take them, please. Don't let me forget. So let's go straight into the OUR. And as I said before, I think OUR will start back at section 18.2 this morning. So OUR, welcome. And welcome again to all the members, and of course, the support staff, and of course, the viewers. So OUR, please take over and just introduce yourselves and proceed.
Thanks, Minister. As usual, Ms. Shani Riley is leading the team, so she will take us forward.
Good morning, everyone. Let me just adjust my screen. Minister, you had mentioned that you wanted me to start at section 18.2. I'm just pulling up our comments to see if I can find that. Okay, that related to the issue of supply. Just a moment. So we had started our discussion on that particular matter at our last meeting with the Joint Select Committee. And I think we had already discussed some concerns that the committee had with regard to the use of system charge. With regard to the definition of supply, the Joint Select Committee had a query in relation to a proposal by JPS to adjust the definition of supply. And JPS's proposal was to expand the definition to read that it means supply with respect to electricity means the activities involved in the sale or provision of electricity to consumers. As we had mentioned in our written comments earlier this year, I think back in April, the use of the term supply in several of the sections of the Electricity Act have been very inconsistent. They have not been consistent with the more restrictive definition of electricity in the Act, where it's limited to the sale of electricity. When you look at various sections in the Act, it's clear that the use of the term supply is more in terms of a generic use of the term that could mean any provision of supply of electricity. And we had given examples that in sections 18.2 and 4, where the provisions relate to the activity of self-generators, it speaks to the sale or other supply of excess electricity. So the use of supply there clearly could not have meant specifically or only the sale of electricity. So we had suggested that the use of the word supply should be consistent throughout. So a decision is made as to how it should be defined in the Act, if defined at all, and then it is used consistently. It should be noted that the more restrictive definition of supply in the Electricity Act, where I said it is limited to circumstances of sale of electricity to consumers, is consistent with the definition of supply in JPS's license, where supply means the business of the licensee in selling electricity to customers. However, it is inconsistent in terms of the use of supply under the Office of Utilities Regulation Act, where there is in fact no definition of supply in that act. So the reference to supply of electricity is assumed to be the normal standard English use of the term, which would include not only the sale of electricity, but any provision, to use JPS's words, of electricity. And we concede that, as JPS has pointed out, that could create a lacuna in the Electricity Act, where all of the provisions and any prohibitions, etc., would only relate to the sale of electricity, but not relate to any supply, any provision of electricity. And that would be kind of a mismatch in terms of the regulatory powers that the OUR has under the OUR Act, where we can and have oversight of any provision of electricity, whether it is for free or for a fee, as opposed to the Electricity Act that seems to restrict the provisions of that act only to the sale of electricity. We note, however, that in terms of JPS's proposed definition, we don't have any strong reservations to it per se, but we do note that it seems to have an additional restriction in terms of relating to the retail provision of electricity as opposed to wholesale because of the use of the term consumers in the definition. We believe that the better approach may be to have a clear indication that the generic meaning of supply would be applicable to all uses of the term in the Electricity Act, as is done with the OUR Act. And we will leave that to the professional determination of the drafters, which is whether or not there should be a specific definition or no definition at all. And there may be need for clear provisions, however, regarding any prohibitions on the supply of electricity generally, whether for free or a fee, and a clear indication that the sale of electricity, certainly the sale of electricity, is subject to licensing and other specific conditions. And we want to make it clear that we are not proposing, for example, that JPS's current monopoly on supply should be expanded beyond the actual business of the sale of electricity or the business of electricity, as opposed to all provisions. it's clear that in JPS's license, its monopoly relates to the business of electricity and the sale of electricity. So we're not in any way proposing an expansion of that current monopoly. But we do agree that it should be clear that the right and ability for regulatory oversight is on all suppliers, whether it is free or for a fee. So if there are any technical requirements, any safety standards, etc., whether it's for free or for a fee, those would apply as appropriate. The committee will recall its concern about this recommendation that persons who establish their own electricity systems through renewables, but want to maintain connectivity to the JPS grid could be affected by a change in the definition of supply in the Electricity Act. From our reading and understanding of the Act, however, we don't believe that the recommendation for an expansion of that definition to include any provision of supply would necessarily impact a person's preference for self-supply and their need for any electricity supply or support from JPS in order to be connected to the grid. Essentially, the definition of supply with or without JPS's proposed amendment, we believe will not restrict renewable energy-based self-generation with connectivity to the grid. And that connectivity would, of course, be subject to all necessary legal provisions and established interconnection criteria. So that is our proposal with respect to the definition of supply, that it needs to be consistent, regardless of what the definition will be in the Act. It should be consistently applied. And our preferred position, which we are proposing, is that a generic use of the term supply be the definition. And then to the extent that there are any prohibitions, any requirements with respect to supply for a fee or supply for free, that be clearly indicated in provisions in the Act. So I don't know if there are any questions or need for clarification there.
I would like to try to get a clarification, and I understand the position in relation to the renewables. There has always been a contention, and probably we could get clarification now from the OUR on your position. The license that JPSCO has enables them to be the sole supplier of electricity by way of a grid system. Now, there is a contention that those persons who used to operate within a free zone or those who now operate within an exclusive economic zone, that there was no contemplation that the license would extend, the provisions of the license would extend to them, as in the past, the free zone was considered to be a purely export activity. And as such, because of the regime, it wasn't deemed to be an operations on Jamaican soil. Has there been any reflection by the OUR on that position? I note that there are a number of persons who are seeking to establish themselves within a special economic zone. And there is a view that they ought to be able, as owner of the businesses inside the free zone or owner of the facility, though they might be leasing it out to other people, whether or not that will be caught within the monopoly arrangement, or that could be viewed, or is it not time, Minister, for us to widen or to broaden our scope and to see whether or not in your negotiations with JPS, those businesses, and these will be new businesses coming on stream, who need cheaper electricity, whether they could be taken outside of that monopoly framework. I wonder if you understand what I'm saying? Ms. Riley? Okay.
Yes, I do understand your query, and it is something that we have had to look at over the years in terms of queries that has come to us. I would ask that we be allowed to defer a response so that I could just have a look at how we've addressed it in the past, so that I don't make any errors and I'm not inconsistent in our response.
Yes.
Okay.
All right.
So maybe later on in this session or at the next sitting,
yes.
we can address that specifically.
If I may,
Oh, thanks, Cheryl is here. Thanks.
I did indicate to Ms. Riley that I would be a little late this morning, but I made it on time, just on time. In the past, we have considered that matter, and we have indicated, as you pointed out, Member Paulwell, that the exclusivity by JPS to supply electricity is actually island-wide as provided in its license. However, if there needs to be an exception for the special economic zone or free zone, then that needs to be explicitly stated in a piece of legislation indicating that. Otherwise, it would be included in JPS's license. We have not had the opportunity to address that issue lately because it hasn't really arisen, but we would then have to examine the Special Economic Zones Act, which was passed in 2016, to see if that in fact addresses that particular problem. If it doesn't, then it will have to be taken into consideration in the Electricity Act, if that is the policy of the government at this point in time.
Yeah, so my suggestion to Minister is, as his team is now going to be coming back to us in relation to the policy of the government, you might want to contemplate that specific issue of enabling operators in the special economic zones to have their own electricity systems. They do complain about the high cost of electricity, and probably that's one of the reasons why we have not seen the massive growth that we were anticipating in relation to the take-up of SSZ licenses. So this might be an incentive for them. Who knows, many of them might still want to be a part of the JPS grid, but I think you might want to contemplate them having an option to establish their own systems, especially because they continue to complain about the high cost of electricity.
Point well taken, Member Paulwell, noted.
I'm now seeking some guidance as to how to proceed. I know the request was that we start at section 18.2 and go down. And I'm not sure if that would have related to the extensive written comments that we would have submitted back in April. Perhaps Ms. McCarthy could give some guidance. Is that the document that you would wish us to go through? Because that would put us at page 19 of 43 pages.
Yes. At the last meeting, the committee had accepted, I think, Ms. Campbell could help me here, 18.3, the recommendation made for 18.3 and 18.4. So I'm seeing you should start at, Minister, could you remind me, I sent you a message earlier.
And I don't think I should receive the remaining amount of work with trepidation. I think we have covered the major issues that could be, could create conflicts. So I think we should be able to go through pretty quickly.
Oh, sorry, member. So, Ms. Riley, it would be 22.2 and 23 and onwards from your recommendations.
Okay, section 22.
2.
Okay.
22.2 and section 23. Up to it's possible. We end up at closing time.
Okay. Allow me to just refresh quickly. So at section 22 that dealt with duties of transmission and distribution and supply licensees. And our comment was that because of the definition in the Electricity Act of Supply, so it goes back to that, the reference to, okay, so I think we would have addressed, let me see. Okay, so I think I would have addressed 22.2 in my previous comment in terms of the treatment of the definition of supply. I think this suggestion here was to make it clear that the reference to supply here is not to the sale of electricity, because then that would have been superfluous. So I think 22.3 would have been the next one, which was a formatting error. I think the closed parenthesis was missing. In the words, including an existing license referred to in section 62. So I think that would have been maybe a formatting issue. Section 23, approval of the local authority for placement and removal of electric line. So in this section, these two sections, 23 and 24, there's a reference to certain obligations of the self-generator as it relates to the placement of transmission and distribution lines. And our view was, because of the structure of the Electricity Act, which contemplates the possibility of having multiple licensees for different components of the electricity business. You could have a discrete transmission licensee, a discrete distribution licensee, self-generators as well, may be able to utilize transmission or have transmission and distribution licenses. Wait. So the proposal was to have a more generalized utilization of the term licensee, rather than making specific references to self-generator or specific references to single buyer. So that was a proposal. So that too would have been a drafting comment for consideration. Sections 23 and 24 also exclude licensees other than the single buyer who may be authorized to have electric lines which run above, below, or along streets, such as transmission, distribution, and other supply licensees. And we felt that a broad reference to all applicable licenses should therefore be included in these sections. So it would be kind of a sanitization of the Electricity Act, where there are obligations and powers that are clearly applicable to any electricity licensee. Use of the term licensee be used instead of specifically singling out the single buyer or specifically singling out a licensed self-generator, because there's a possibility that you may exclude other licensees who do in fact have these powers and obligations. So I think that was more a drafting point. Section 25 and section 27 have to do with way leave agreement and arbitration. And our comment is that as the Electricity Act contemplates the possibility of supply, distribution, and transmission activities being conducted by separate electricity licensees, even though that doesn't occur, no. The way leave and arbitration provisions should also be made applicable to these potential licensees and not solely be applicable to the single buyer as contemplated in the current draft. So similar to the sections before, we are proposing that you make a reference to licensees as opposed to single buyer in these sections. So it is suggested that the reference to single buyer in sections 25A and 27 be replaced with licensees. Also, the reference to supply line in section 25 should be replaced with a more generic term such as electric line, because it could be a transmission line or a distribution line. And the reference to electric line restrictions in section 27 may in fact be a reference to way leave arrangements and should be amended accordingly. So these were drafting comments and less so in terms of substance. Section 28, offense of cutting electricity lines. Because of the current very specific definition of supply in the Electricity Act, its use in Section 8 seems to exclude an intent to disrupt the transmission or distribution of electricity from the offense. So it's specific to disruption of supply, but not to the transmission and distribution. And so it's recommended that the offense be extended to damage of transmission and distribution lines. And so we had proposed some language for consideration that you would, at the end, insert the words intent to disrupt any transmission, distribution, or supply of electricity commits an offense. So it's clear that all components of the business of electricity, the business of electricity is contemplated. Section 29 and 30, right of entry to premises for inspection and offense of obstructing an agent of the single buyer. The Electricity Act contemplates the possibility of a supply, distribution, and transmission licensees, separate licensees, other than only the single buyer, and therefore the rights of entry accorded by sections 29 and 30 should be applicable to all such licensees. So again, a drafting point that the act be sanitized and remove where appropriate references to single buyer and replace them with licensee. Section 31, I think there was this related to power of minister to cause line and work to be removed. I don't have the act in front of me, but I think the readability of that provision had some problems. So we had proposed that the draftsmen just have a look at it and see if the readability can be improved. So again, a drafting point. Section 32, right of easement. As the Electricity Act contemplates supply, distribution, and transmission activities being conducted by licensees other than just the single buyer, the similar rights of easement and obligation to compensate for easements should be conferred to such other licensees. So that goes back to the comment I made on the previous sections in terms of the right of entry and obstructing the agent of the single buyer. These should be references to licensee if ever the structure of the electricity sector is such that we no longer have a single buyer, or we still have a single buyer, but we have a transmission licensee separate from a distribution licensee and multiple supply licensees. So again, that's the proposed sanitization of the legislation. Sections 34, 35, 36, 37. These relate to notice to owner of land, joint use of poles, fair compensation for use of poles, and compensation. Again, similar comment as before. A proper reference in these sections should be to the holders of supply, distribution, and transmission licenses rather than just a single buyer, because these will be rights and obligations of anyone who holds the license to transmit or to distribute or to supply if the current structure of the electricity sector changes, and therefore there should be a clear reference to all of those other licensees and not just a single buyer.
Ms. Riley, for you clear, which section were you speaking of just now?
34, 35, 36, okay. 37.
Okay, thank you.
Section 38, lines, meters, etc., not subject to distress. Again, as with the preceding sections, these should be clearly made applicable to any holder of a distribution license or transmission license or supply license, if ever the structure changes and there's not just a JPS doing all three components. And so again, drafting, it should be made clear that it's applicable to whoever is the holder of those licenses. Also, in light of the definition of supply in the Electricity Act, a reference should be made to transmission and distribution of electricity, as well as to electric lines, as all the lines and equipment mentioned in these sections are not only used for the supply of electricity. There's a reference to undertakers in section 41, which may have been an accidental carryover of the term from the old electricity legislation that has been repealed. And so another drafting point that needs to be amended. The intention may have been to insert single buyer there, but as with the previous sections, we propose that it be made applicable to the supply, distribution, and transmission licensees. Part 4, System Operator, Section 44, Obligations to comply with the system operator's direction. Section 44.1, the system operator does not give directions, but gives instructions. And further, the instructions must be in accordance with the relevant codes and the terms and conditions of the relevant agreements. Therefore, reasonable boundaries for compliance with instructions should be established under the Electricity Act. We are proposing the insertion of the words subject to the provision of the relevant codes, and it would be capital C as codes are defined in the Electricity Act, and the power purchase agreement. A generation licensee shall comply with all instructions of the system operator relating to dispatch activities or other functions of the generation licensee that concern the system operator. So that is, again, a drafting point so that the provision clearly reflects what actually occurs in the electricity sector. Section 44.2, this section criminalizes the failure to comply with the system operator's instructions. However, the power purchase agreements that JPS will enter into with various IPPs allow for some forced, scheduled, and maintenance outages and agreed dispatch deviations. Therefore, if the licensee is unable to comply with the system operator's dispatch instructions outside of those conditions that you are allowed to deviate, then liquidated damages apply under the power purchase agreements. It's therefore suggested that the failure to comply with the system operator's instructions should first be addressed under the applicable agreement in terms of the applicable contractual and technical arrangements, because it could be a deviation that's permissible under the power purchase agreement, or it could be a deviation that can be compensated via liquidated damages under the power purchase agreement. And then when there is no reasonable justification for the breach and no appropriate sanction, then the criminal sanction can come into play. So we're actually recommending a more tiered system rather than go straight to criminal sanction, because some of these things may be more appropriately dealt with under the contract and contractual and technical requirements as opposed to the criminal law. So it is suggested that the language in 44.2 be amended to reflect, for example, a licensee who without reasonable justification fails to comply with a direction under subsection 1 commits an offense. And maybe that may require further amplification and further drafting. But certainly from our perspective, our proposal is that the first stop be to the technical requirements and the power purchase agreement and any remedies thereunder. And then where those do not apply, then you move to the criminal law. For section 45, duties of system operator redispatching activities, that's the heading. Sections 45.1, section 45 requires the system operator to separate dispatch activities from transmission activities and activities relating to generation, distribution, and supply. The drafting of this provision, however, contemplates that the system operator will be the single buyer. It presumes that the system operator will be the single buyer, which is the case now. So that is actually reflective of the current market structure. But we are reminded that the Electricity Act contemplates the possibility of having a standalone dispatch licensee. And so that possibility, we think, should be reflected in section 45. So again, this is a drafting point to kind of sanitize the legislation to not only reflect what currently exists, but to reflect what is possible with the separation of the different activities under potentially different licenses.
Could you just pause a moment?
Yes.
Because I think that is a very important issue, that of dispatching. Because I think it was originally contemplated that an independent body like the OUR would be the most appropriate body to ensure transparency, complete transparency in dispatching based on the merit order system. And probably we are at that point where that should be invoked and be operationalized. And probably the OUR could explain to us whether or not it can take up this function and how quickly it can.
Okay.
In light of the questions that have been raised, issues raised about gas, and even though you have take or pay situation, I think to put it in the hands of an independent body might answer some of those questions. Eh?
Okay. I don't know if any of my team members have a view in terms of how practical that would be in light of the current construct, and if there's any potential conflicts between us being the regulator of the sector and actually having such an operational function. Or perhaps this is something that we may want to come back on. Any of my technical team.
And just so that other members of the committee are following, you have a number of people who generate electricity. When that electricity is generated, a decision is taken as to which of the generated electricity goes onto the system or go onto the system, and that is determined internally by JPSCO. You have a number of independent providers of such electricity, and oftentimes you get the complaint that my electricity, which is cheaper, is not being taken up in sufficient quantity and so on. And that's why this issue of dispatching electricity from producer to the grid is crucial, and why there is a sense that at this point, we might need to have it in independent hands to make that determination.
So, might I?
You're the boss.
Right. So Minister, I mean, Minister members, I know about the debate that has been going on. Unlike Sheni, I think we perhaps will need to have a little bit more internal discussion before I give you a definite answer on that. I do worry about the regulator getting into such operational matters. I think that what is critical is that there is a transparent dispatch mechanism so that people know what is being done and how it is being done. So if we can put in place a system that allows real-time access or look at what is happening, then we should get rid of the issue of whether dispatch is being done fairly. As to whether you want the regulator to actually be making the decision as to what goes online and what goes offline, that's something I'd need to think a little more about and have some further discussions with our engineering people, but I'm a little skeptical about that one. But I know there are others on that may want to, I don't know if I'll want to weigh in on this, for example, given his experience.
Let me get my camera on. Good morning again. To the point of dispatching, as mentioned by Member Paulwell, actually, we have a mechanism, albeit it is not an online mechanism, to monitor the credibility of the merit order dispatch. We currently received requests on a monthly basis, dispatching records for each hour of the particular month, which we examine to ensure that the merit order system is being consistently followed. The issue sometimes is that there are constraints to the functioning of the merit order system constraints such as transmission lines, out of service, or other maintenance issues. This we also look at, but to Director General Answer's point, it is not an online system. An online system would require tremendous resources to mimic or to manage on a real-time basis the dispatching function. But we do have offline capability to review and to notify when we see a variation from merit order dispatching, but it's offline.
Member Jackson wants to comment, so let me reserve until he says his piece.
Yes, good morning, Minister. Good morning, fellow colleagues and members of the committee. If I understand Member Paulwell's point, which is one that I share that concern with, is to remove from the operator the sort of absolute role in determining how and when someone comes onto the system, because I too have heard some of those complaints that he referenced. And what I'm thinking is a way forward PD at utilities, OUR, is for a framework to be established, determining all the protocols relating to that exercise. And then JPS will be then required to deal with each applicant according to those protocols. As the regulator, I would have known, for example, as a provider, a domestic provider, what those are. In other words, what are the standards? What are the requirements for me to be on? I would know what those are beforehand, and I would seek to fulfill them. If I fulfill them and have documentation to substantiate it, and JPS fails to do that, then that's where the OUR would come in as the regulator. So yes, you would not be involved in setting anything, determine when they come in, but you determine the framework within which they ought to be in. And I believe if an approach to that is in place, you would then be carrying out the regulatory function as you do in other aspects of the utility provider.
Member Jackson, my position is slightly different from yours, because there is in fact a framework. It is a system that is called merit order.
Yes.
So the cheapest supplier who has a take-or-pay arrangement utilizing a non-fossil fuel generating system might be first in line, right? So there are various criteria as to who will come on 1, 2, 3, 4, 5. And that is what the JPS is to ensure. And yes, by some post accounting the OUR gets involved. My view is that it probably ought to be far more active and involved at the operational stage. And I heard Val saying that the system is not online, so there can't be active monitoring of what is being dispatched. And probably that is where a solution lies, that resources really ought to be found. And if the OUR believes that it might be difficult for them to pursue that arrangement having regards to their other functions, then it might have to be a discrete body comprising of independent people who could have that online monitoring so that it doesn't have to wait a month or so. Because I don't know why I get complaints regularly from the private power producers that this dispatch system is not working fairly. And even just to dispel that from the ongoing conversation might be a useful thing. You know what I'm saying, Fitz?
Yes.
And if I can come in, Courtney Francis here from the OUR through the chair, if I may. Just want to add a few comments to the discussion. So,
are you able to put on your camera?
Oh, yes, indeed. See me? So based on the current construct, we operate under what we call a system operator. But in most mature markets, we have a high participation of private generators like IPPs. And in the case of Jamaica, what you want to do to ensure for transparency, as Shanae alluded to, we have to try and decouple the operational function as it relates to dispatch and giving instruction from the utility itself. So one of the fixes in the interim, and that can be accomplished through this actually review process. And indeed, the OER will be looking internally also to see what we can come up with. But one of the strategies is to establish a fully independent system operator. And that would be essentially a separate body from JPS, and that body has specific roles in the sector. And I think that will alleviate much of the problems that we are encountering. Notwithstanding that, the OER will still have some responsibility to look at the dispatch process, because at the end of the day, we are trying to ensure that we have lowest cost to consumers. But the independent system operator model is something that we have talked about. And I think that is high time now that we start looking more deeper at that construct.
I agree, fully agree.
Thank you, members, for those interventions. Or you can continue.
So I'll continue at section 45.3. This provision requires that the minister, in consultation with the system operator, may require additional arrangements regarding the establishment of such a separation. And I think that is the separation of the transmission, generation, distribution, and supply activities from the dispatch activities. Such activities of the minister to be performed under section 45.3 should be exercisable at the level of the regulator, as they involve organizational decisions of the single buyer, which may be necessary later on, and which may impact costs and ultimately the consumer. So the proposal is that for 45.3, it could be redrafted to read: the office, in consultation with the system operator, may require the system operator to make additional arrangements in a manner satisfactory to the office to further establish the separation referred to. So we're suggesting that that be a function of the regulator rather than the minister. Section 45.6, the provisions regarding recovery from consumers in this section may potentially be applicable to a supply licensee and not only the single buyer. So this section should therefore be adjusted accordingly. So the proposal is sanitization of the act to make a reference to a supply licensee and not to the single buyer. Section 45.13. It's proposed that the Act explicitly include a provision as to what happens after a report is received by the office. And I think this relates to where there is I think, disruption in the dispatch activities. What currently obtains is that the OUR assesses the content of the report. It then conducts its independent investigations. And if it considers it necessary to do so, it will prescribe remedies, recommendations that it deems appropriate for implementation by the licensee. So we had proposed that the provision read, on receipt of the report, the office may conduct such investigations and make such recommendations, determinations, or issue such directions as it deems appropriate. So that's language to kind of expand the provisions as it relates to disruptions in dispatching activities and the functions or the investigatory functions of the OUR. Section 45.14, in light of the OUR's monitoring role, we believe it may be appropriate for the OUR and not just the minister to receive timely updates on major system failures and to be kept informed of the progress of the works being undertaken to restore the system. Currently, it is for the minister to receive those reports. And so it is suggested that the section be revised to reflect the system operator shall provide regular status updates to the minister and the office until the system is restored. That is currently the case. However, since it's specifically referenced in the statute in terms of the powers of the minister to require these reports, we thought it prudent to add the regulator as well. Section 45.15. According to this condition, the system operator commits an offense if it contravenes any of the provisions of Section 45. And there are several provisions that deal with dispatch, that deals with system disruptions, provision of reports, etc. And however, if the office's investigation found that a major system failure was caused by negligence of the system operator, the Act does not mention any specific penalty for the system operator to serve as a deterrent. And so it is proposed that possible contraventions arising from Section 45 be included as offenses which are subject to the fixed penalty scheme under Section 54 with an appropriate range of monetary penalties that are suitable for each specific offense. So the proposal is that breaches by the system operator of Section 45, some of them be included in the list of offenses that are set out in the fixed penalty schedule. Section 46, the title Single Buyer to Maintain Separate Accounts. Under Section 41, the accounts being referred to are regulatory accounts and not financial accounts. In addition to the obligation, the regulator should also have the authority to prescribe the system of accounts to be maintained. This will afford an additional safeguard against the use of systems paid for by ratepayers to earn non-regulated revenue, which is not captured in the computation of returns. We also believe separate accounts should be required where licensees acquire generation on a competitive basis to avoid cross-subsidy by the regulated business. So it's recommended first that the title of this part 8, and the marginal note of Section 45 be made to make reference to licensees rather than the single buyer. So again, going back to that sanitization of the Act to cover any structure of the sector that may exist at the time. And it's also suggested that Section 46.1 be amended to read, licensee shall at all times keep the accounts and records for its generation, transmission, distribution, and supply activities separate and distinct from each other and from the accounts and records kept in respect of any other part of its undertaking or business in such manner as may be prescribed by the office from time to time. And this is not unusual. Currently, we do exercise powers to prescribe regulatory accounts that may differ from how the entities may maintain their financials for normal audited accounts, etc. And that's to enable sufficient transparency and oversight by the regulator to ensure that there are no cross subsidies, etc., from the different lines of business. It is also suggested that provision specifically require that in respect to its generation activities, a licensee shall keep separate accounts for any generation capacity that is procured on a competitive basis or pursuant to Section 24 in the case of the single buyer of the Act as directed by the office. So this, and I'm going to ask maybe my technical team to assist me here. This would relate to an instance, for example, where JPS exercises, where JPS competes in a competitive tender for new generation capacity. And based on that, we would wish to see that particular facility, the revenue flows and the costs from that specific facility to be separated from the rate-based activities in its normal electricity operations, because that particular generation facility would have been procured under separate circumstances. Yes, under the powers of its license, but under very separate circumstances. And so we would want to ensure that there are no cross subsidies and that there's transparency in terms of revenue flows and costs between those two activities. I would ask maybe one of the technical team members, maybe Courtney or Val, if you could explain that a little more clearly. I don't think I've done a great job.
So, Shane, I think you have addressed it, largely. Sorry, I think you have addressed it largely. The concept of the rate base, and because we have a competitive generation arrangement according to the Act, what you want to do is to isolate those costs as much as possible from JPS's normal business, licensed business, to ensure that you don't have transfer costs and the depreciation expenses are not mixed up. And again, you don't have any cross-subsidization of any costs where consumers are taking up costs on one side, which is the rate-based side, and that might also be taking up costs on another side. So the essence of it is to ensure that we have a red line or a ring fence around the assets for procurement under that kind of construct, and that is fully separated from the rate-based arrangement, which constitutes the existing assets that the company possesses. So the essence of it is a strict ring fencing of those elements of costs related to those assets in a similar way to how we address the ROFO arrangement. Don't know if there's any questions around that.
Okay, thank you. I think you did a good job, Courtney, because there are no questions. Thanks for that.
I hope so.
In terms of section 46(2), so 46(2) relates to the single buyer engaging in any other business in addition to the activity it conducts, pursuant to its electricity license, but no revenues, costs, profits, or losses resulting therefrom shall be taken into account in the fixing of rates by the office. So that's what 46(2) says. So the proposal is that there should be specific provision for the reporting of transfer prices charged for transactions between the single buyer's business to the office and for the conduct of audits by the office. Transfer prices refer to the accounting value assigned to a product or service sold in a transaction between different divisions of a company or companies belonging to the same corporate group. The intent here is to ensure that there is transparency in the business transactions of a licensee, so as to ensure that there are no cross subsidies, so a similar point, between regulated operations and the unregulated business is kept financially separate from that regulated business. So the suggestion is that the licensee shall furnish to the office such reports of transfer prices for transactions between its licensed operations, that is generation, transmission, distribution, and supply activities, and between its licensed operation and any other part of its unlicensed undertakings or business as the office designates. Then part 9 addresses the various codes. Section 47.1 says that the office, with the approval of the minister, shall prepare and promulgate each of the codes within 12 months after the appointed day for the general direction of licensees in respect of the matters within the scope of each of those codes. We propose that the office should be permitted to develop and prescribe codes other than those specifically referenced in the legislation as the need arises. And in light of this provision, provision should be made for the development of codes from time to time. So I believe the codes were very specifically defined, but we recognize that as the electricity sector develops, as technology changes, there may be need for other codes. And so I think in our earlier comments, we would have proposed that the definition of codes be expanded to include a sweep-up clause where it relates to the specific codes mentioned, and let me see if I can find it quickly, but any other code that may be promulgated from time to time. Okay, yes. Any other codes that may be developed by the office. So the proposal was that there be an expansion and that this particular 47.1 give recognition to the power of the office to develop codes from time to time, and that be reflected here. Excuse me for a moment, I just lost my place. Yes. Additionally, it suggests that they reference to the preparation and promulgation of the codes within 12 months of the appointed day be removed because that is now obsolete. So that would be replaced with just simply the power of the office to prepare and promulgate codes from time to time. Section 47.4, where it speaks to a breach of any of the codes by the licensee or a self-generator who is not a licensee shall constitute an offense. I think our concern here was that the merit of enforcing compliance with the codes by an unlicensed self-generator is unclear. And so the proposal is that that reference be deleted. And instead, the offense of breaching the codes be an offense of the licensees, whether it's a licensed self-generator or one of the other licensees under the Act. In terms of 47.5, the office shall review the codes every 3 years, and in conducting that review shall consult the stakeholders in the electricity sector in such manner as the office considers appropriate. Here, the obligation to review the codes should be framed as a minimum period of review, so that if the need to revise one or more of the codes at an earlier interval arises due to changes in the sector, and so that review would not be constrained by the current language in the legislation. Also, it's recommended that a longer period be set for this minimum period of review. So rather than 3 years, a longer period be considered. The review of the codes are quite extensive, and except where changes occur in the industry, it's proposed that the code be reviewed at least once every 5 years. So the obligation for review be set at 5 years, but the language of the provision should be such that it allows for earlier review as necessary. So we had suggested some language, but we do concede we're not draftsmen. The office shall review the codes at least once every 5 years, and in conducting that review shall consult the stakeholders in the electricity sector in such manner as the office considers appropriate. 49, that section deals with the government electrical inspectorate or regulator, the government electrical regulator. 49.4 in particular says that a licensed electrical inspector shall certify that any premises, facility, or apparatus is fit to be connected to the system if he is satisfied that the electrical wiring and installations at the premises, facility, or apparatus are safe and comply with the codes, and that's capital C. Our comment is that the codes are, as currently defined, do not cover the requirements for the inspection and certification of electrical wiring and installations at customer premises. The codes as exist actually regulate the operation of the grid infrastructure. So the provision should instead make reference to appropriate regulations and industry standards rather than a reference to capital C codes, because those are specifically defined. In 49.5, the single... Oh, yes, member.
Yes. Chairman, if I could just comment on this, especially as the matter has been recently in the news, the JPS got complaining vociferously about the high price that our new qualified licensed electrical inspectors are charging. As it's been proposed by Ms. Riley, that further regulations are necessary. And I agree with her. Probably also, you will want to contemplate how we're going to ensure that there is fair competition, because I know you're relying on the competitive forces to keep prices down and to provide better quality service. It appears as if we're not getting enough persons qualified to become inspectors, and probably that might be an answer to the question, but also how you can engineer such regulations that will promote competition. They were asking for price fixing, but that might very well be in breach of the Fair Competition Act, and I wouldn't support that. But I think it is necessary, as you are relying on competition, to see how through regulations we can improve on the competitive element, the competitive spirit, so that we can see reductions in these prices, in the cost. So Minister, I'm hoping that you will follow up on that in relation to the regulations for the inspectors.
Remember, I've gotten quite a number of correspondence and complaints and issues with the government inspectors that were there before, and them being not able to qualify for categories going forward. So all of those are going to be incorporated in this review to see how best we can treat them. So we'll have further discussions on that.
Just to continue, section 49.5, that section speaks to the single buyer shall not connect any premises, facility, or apparatus to the system unless it has been duly certified by a licensed electrical inspector as fit to be connected to the system. And this just goes back to our previous comments that this may actually be an obligation of any other supply licensee to the extent that the structure of the industry changes and there are multiple supply licensees. And therefore, we believe the reference to single buyer should be replaced with a reference to the supply licensee. Under section 51, which deals with the Electricity Appeal Tribunal, we are proposing that the provisions in this section actually include a minimum period of time within which a licensee should pursue its appeal after having filed its appeal. There may be appeals which a licensee is no longer interested in pursuing, but it just hasn't taken any steps in the tribunal to have the matter withdrawn. Until it is withdrawn, certainly from the perspective of the OUR, it is still a live issue. And in order to get it removed from the record, so to speak, we would have to expend monies and times to have it dismissed for want of prosecution. So the proposal is that a reasonable time be contemplated as a minimum period within which appeals should be pursued, and this be included in the provisions that address the operations of the Electricity Appeal Tribunal. Section 53, that section deals with the penalty clauses. It speaks to any person who commits an offense under the Act for which there is no penalty specifically provided under the legislation, then they will be liable to conviction in the, well, I guess in the new promulgation, it will refer to the parish court rather than the resident magistrate's court. And it sets out what the fine would be for an individual offender vis-a-vis a body corporate. We are suggesting that the provision just be looked at again because it appears that while it speaks to the penalty for the individual offender, it seems to have omitted the penalty applicable to the body corporate. So that's a drafting issue. 54 sets up the fixed penalty regime. And currently it only covers 3 offenses. So it is proposed that the schedule be expanded to include additional offenses so as to incentivize compliance. The offenses in the Act that are best suited for treatment under the fixed penalty scheme should be identified and added to that schedule. So that is our recommendation there. For 55, section 55. So this speaks to regulations that are made by the minister. And it sets out the different types of regulations that the minister is empowered to promulgate. We are proposing that the OUR, or the regulator of the sector, should also have a power to make rules to better regulate the industry and provide transparency in the exercise of powers granted under the legislation. So while we have the general powers to regulate, we think it is a good rule of practice for regulators where possible to actually set out via rulemaking how we operate and the considerations that form the basis of our decisions. So we were not granted any specific rulemaking powers in the Electricity Act. We recognize too that given the dynamic nature of the sector, we may need to modify rules, particularly technical rules, very rapidly. And therefore, we would wish that there be some flexibility in the grant of that rulemaking power, if it is in fact granted, so that we can respond quickly current or anticipated developments in the sector. We propose that the rulemaking power be by order published in the Gazette after consultation with or subject to the consent of the minister, and that we believe would be a more efficient and effective mode of providing the flexibility needed to make and adjust rules quickly to address issues occurring in the sector. It is also suggested that the minister's powers to make technical regulations should be subject to negative rather than affirmative resolution. Currently, all of the minister's rulemaking powers are subject to affirmative resolution. It's believed that that would be more effective and efficient in quickly promulgating more technical rules, so that if once it is laid in the House of Parliament, it can take effect to address issues in the sector quickly. But then if there are views that there are lacunas or any inadequacies in those rules or need for amendment, the Parliament will still have the power by negative resolution to withdraw those regulations or have them modified. And again, we suggested some language that would be similar to that exists in the Telecoms Act for the OUR's rulemaking powers, which says the office may, and depending on what is accepted after consultation with or subject to the consent of the minister, make rules published in the Gazette prescribing any matter required by this act to be prescribed by such rules, or any matter that it considers necessary or desirable for the effective performance of its functions under this act. Section 58, which addresses unlawful abstraction or use of electricity.
Mr. Chairman, may I come in here and have a comment?
Yes, we're welcome, Member Hill. I was wondering where you were all this time.
I've been here while you were looking at whatever you were looking. Here I am. I have a comment here. Constantly bearing in mind the principle that it is the elected that must make policy, and it is to the elected when regulations or policy go awry that the people go to. They don't go to the OUR. They don't go to anybody else like that, not even the Bank of Jamaica when things go awry. They come to the elected people. So I wouldn't want to move away from the affirmative resolution in Parliament. I hear that you're going to consult, you're going to submit your whatever you want to change in the rules to the minister. But I want that to be more tightly written in that it gives the minister time and the minister will give him time to check with his technical people and or his ministerial colleagues. Think about that some more, because I want you to have the flexibility, but I want the OUR to be constantly aligned and with the understanding that this is not going to stop with them. They're going to have to make the case to a responsible minister and or his colleagues. And you can set a time when the minister should come back to you. I don't have a problem with that. I don't want the minister to make it stay on his desk forever. So I don't have a problem with that either. The minister must also be efficient. But I do not want power to be downloaded constantly from the elected people who, when anything goes wrong, it is them, not to anybody else, that the population go to, and it's them that they hold accountable. That's a principle that I subscribe to and believe in. And so when you're drafting that change as you are requesting, you draft that in mind so that when it comes back to us, we can see that it's properly held. And I don't mind if you put a timeline in there, a reasonable timeline for which a minister should respond to you, so that you don't have this thing held up forever. Thank you, Chairman.
Thank you, Member Hill. Noted.
And if I may just add, I appreciate the concerns of Member Hill. And we can actually utilize how we operate under the telecoms legislation by way of example, in that we do in fact have that power to make rules and regulations, and most of them are technical in nature. We operate as an administrative body in a consultative way and as a regulator very transparently. And so usually before we issue rules, we do engage relevant stakeholders in a consultative process and then issue our decisions. And then we will provide our recommended approach to the minister where it relates to rules that must require consultation with the minister. And then those rules are promulgated. So I do appreciate the concern and the need to ensure that major decisions that can impact the sector do not become law in a clandestine manner. So we do appreciate that. But certainly how we operate, and as is required by legislation, we do consult before making decisions, before issuing rules. And that is something that we would expect to be reflected in the Electricity Act as it is done in the Telecoms Act as well.
Well, you codify that consultation, but what I want to make it clear is that I do not believe an unelected body has the right to make policy rules. And although it's technical, the minister can get technical advice from his team. Very often technical people write things and yeah, they take a broad understanding, but a minister and his colleagues will have a different understanding of the effect they might have on people. So bear that in mind as you codify it, otherwise you're going to have to go back and rewrite it, because that power must not be downloaded to unelected people. Unelected people will give advice. Once you say you want something done, draft it in a certain way that it can be done, but not leave out the elected officials who must take the responsibility for it in the end. And as I said to you, they must not sit on it forever. So make a timeline for them to give it back to you too. No problem. All right? Thanks.
I think the next provision is section 58. That provision addresses the unlawful abstraction of electricity and makes it an offense that's liable to summary conviction in the parish courts. The offense of unlawful abstraction and use of electricity should also be applicable to electricity that may be transmitted and distributed, and not only to electricity supplied. And therefore, the reference here should be to all electricity licensees. The provision actually speaks to any person who unlawfully abstracts, uses or consumes, diverts or causes to be diverted any electricity supplied by a single buyer. So it's very specific to single buyer. So a drafting point again, that this should be applicable to all electricities licensees and not just the single buyer in the event that the structure changes.
Yes, I agree, point taken.
Okay, section 60 is review of the act.
Before you move on, I want my agreement to be recorded as well. I also agree. Thank you.
Okay. For section 60, review of the act. This speaks to the provisions of the act shall be reviewed by a joint select committee of the Houses of Parliament no later than 5 years after the appointed day. So this is a drafting point. So this clause will now be obsolete. However, we do see the value of periodic reviews of the act, and that it should be ongoing and included as a requirement in the legislation. This is of particular importance with the significant milestone that will be upon us in 2027, which is the expiration of the JPS license. And therefore, it's proposed that a review of the sector take into account any anticipated changes to the sector structure. And therefore, that would be prudent to be done before the expiration of that license. And so we had proposed some language for consideration. The provisions of this act shall be reviewed by a joint select committee of the Houses of Parliament at least once every 5 years.
Chene, I agree with that. And I like that the sunset clause effect of that rendition. And it's absolutely important that we keep that in and keep it going because it's necessary. Thanks.
A crucial point that she raised is the fact that the license will terminate in a relatively short period of time. So it is important that the legislative framework for an entirely open system for generation, which now exists, and distribution can be reviewed and be put in place in anticipation of that. So I agree entirely, Minister.
So the next set of comments relate to the schedules to the Act. We had mentioned earlier that a further review of the first schedule be considered to expand the list of penalties that are set out in that section to which the fixed penalty regime would be applicable. In terms of the second schedule that deals with merit order dispatch, in paragraphs 1 and 2, merit order system is referenced to the generation code, but this is more comprehensively addressed in the dispatch code. And there is a lack of specificity in the use of the term licensee in these paragraphs as well. And so the proposal is that paragraph 1 should be modified to read, the system operator shall establish and operate as part of the generation and the dispatch codes a merit order system. So it would not be a reference to as part of the generation code, but out of the generation and dispatch codes, a merit order system. And references to licensee in paragraphs 1 and 2 should be replaced with the system operator for consistency with the use of the term in the codes. So those two are drafting issues. We had also recommended some additional provisions for contemplation, and one relates to consumer protection and resolution of complaints, which is not addressed in the Electricity Act. We feel that it's critical that the Act be comprehensive. And so while the regulation of the sector is addressed both in provisions in the Electricity Act and the Office of Utilities Regulation Act, we think to the extent possible that we have a more comprehensive piece of legislation in the Electricity Act that deals with all components of the electricity sector, the obligations and rights of the stakeholders in the sector, and how particular things can be addressed in terms of safety, as well as the protection of consumers and their interests. Therefore, it is proposed that provisions be included in the Electricity Act that deal specifically with consumer rights and protection. Provisions are required in this legislation in order to give teeth to the consumer protection and dispute resolution issues that are, for example, not comprehensively addressed in the OUR Act either. The Electricity Act does not address the issue of prescribing quality of standards for consumers or the resolution of their complaints, especially in addressing the vexed issue of equipment damage, for example. Currently, these are addressed in any contracts that the service provider, the utility, may have with its consumers. And to the extent possible, there may be issues that are placed in the licenses that address things such as guaranteed standards. But to elevate some of these issues in a general way at the level of the legislation, we think would give more teeth and a greater understanding to persons in the sector and persons who will potentially enter the sector to be aware of what their obligations are to consumers.
Minister, can I just comment on this one?
Go ahead, Member Paul.
Yes, when the law was being drafted, there was that issue of consumer protection. And at the time, it was acknowledged that we do have a Consumer Protection Act. I was a minister who had promulgated that, which gave very broad powers. And for example, we were able to extract from the UK some of their unfair contracts terms provision to regulate against super large bodies imposing by virtue of their strength terms and contracts on small consumers. So we do have a body of law to protect consumers. I believe that many of the consumers are not aware. But I am now agreeing with you that we should probably incorporate some of those same provisions, and it's not going to be superfluous for that to happen, or the effect will be because I think that consumers need to know that there are specific provisions in the electricity law that will offer them protection. I recently saw where the OUR announced payments over 200 million that you have mandated the JPSCO to settle for breaches of standards. And sometimes the consumer ought to be encouraged based on the provisions in the law that will give him that power to make his own submission for damages, utilizing his own counsel, ensuring that there's a private right of action, for example, in these matters. So I'm agreeing with you that we probably need to extract from the Consumer Protection Act and to add to that issues relating to standards, and so that if you have damages caused by high voltage, etc., consumers won't even have to approach the OUR. They can say, this is the law, I'm approaching you, JPSCO, settle or else. You know, so I'm agreeing with you in that regard.
And additionally, this is perhaps looking forward, if we do in fact have a sector where there are multiple supply licensees as well, instead of having to address these issues only in their license provisions, there could be some overarching rules that are set out in the legislation to address these consumer protection issues. The OUR does have powers under the OUR Act to address consumer protection matters. There is, in fact, a power to undertake such measures as it considers necessary to protect the interest of consumers in relation to the supply of prescribed utility services. But we think it would be useful to have this specifically identified, protected, and expanded in the Electricity Act, specific to electricity sector. And we had suggested some language for consideration. The office may, after consultation with licensees and with persons appearing to the office to be representative of persons likely to be affected, prescribe such standards of performance in connection with the supply of electricity services to customers as, in its opinion, ought to be achieved in individual cases, and shall publish such standards in the Gazette. So we have the whole issue of consultation. So it won't be simply these rules being implemented without feedback and hopefully buy-in from those who will be affected, but also publication of it in the Gazette. Continuing, standards of...
Chair, if I might just interrupt Ms. Riley for a moment. Have you looked at the Consumer Protection Act vis-a-vis the provisions under the OUR in relation to what you're proposing for electricity now? Because I hear you, I think I'm tending to agree with the other members in relation to a need for it to be captured in the Electricity Act, but I'm just wondering the extent of the provisions in the Consumer Protection Act in particular, and how effective those provisions would be in relation to a customer aggrieved.
So I would say that the Consumer Protection Act has a more broader effect in that it addresses issues across different types of sectors and different types of transactions and arrangements between suppliers of goods and services and their consumers. But there is always room for sector-specific legislation, actually providing very specific rules and standards that are particular and peculiar to that sector in terms of the experience of those particular consumers. And we do have something akin to that in terms of even how we collaborate with the Consumer Affairs Commission in relation to telecoms matters. So there are some very specific issues that may arise, for example, in the telecoms industry, and even with the guaranteed standards that are applicable to the Jamaica Public Service Company as well as the NWC that may arise, and where complaints are submitted to the Consumer Affairs Commission, they collaborate with us at the OUR to address those issues because we are more au fait with the standards and the technical issues that would apply. So there's a possibility of some overlap, but I don't necessarily believe that they would conflict. And there is an advantage to setting out in sector-specific legislation standards and protection mechanisms that are specific to that particular sector.
So then my next question would be, would we then be looking at setting out the particulars of the standards that must be observed without putting the responsibility on the OUR to be the person who manages those complaints? Is it that the Consumer Affairs Commission would still manage those complaints, but be guided by the Electricity Act and the detailed provisions in relation to how customers are treated?
I believe that's how it operates now with the JPS standards and the NWC. So yes. And
you propose that continue.
And that continue, exactly.
Okay. That I wasn't clear on that.
Right. So the roles are similar in terms of the support to consumer interests that both entities give, but they're different. In terms of the CAC being more hands-on in terms of the advocate for the consumers, whereas the OUR has the role of maybe an arbitrator, distilling the issues between the utility provider and the consumer. So for example, the CAC could actually submit a complaint or an appeal to us on behalf of a consumer as well. So it's maybe it's gray, but it is different. And I hope I'm not speaking out of turn, Colette, if she's on, but I think we have been able to operate collaboratively without actually clashing or conflicting in terms of our different roles.
Yes, okay, thank you. And certainly the drafting would direct that.
Yes.
If I may just make an additional point to what Ms. Riley has indicated. In fact, the CAC and the OUR currently has a memorandum of understanding where we set out how we operate within the two spheres. Oftentimes what we do find though, and what CAC has indicated to us, because of the technicalities of some of the issues that they face, they are not really capable or have the expertise there to actually opine on it. So what we have said, refer those matters to the OUR and we will deal with those matters. So we do have a regulatory framework where we work in a very consultative and collaborative manner. And so the concurrent jurisdiction will not conflict at all once we set up that framework and work effectively within it.
Thank you.
Just continuing in terms of the proposal, we had suggested what some of these standards of performance would address. Standards of performance under this section may, so it's not exclusive to these things, prescribe circumstances in which a supply licensee is to inform persons of their rights under this section, prescribe such standards of performance in relation to any duty arising under paragraph A, which is circumstances of their rights, as in the office's opinion ought to be achieved in all cases, prescribe the scheme of compensation to be applied in circumstances of breach of such standards of performance, and prescribe circumstances in which a supply licensee is to be exempted from any requirements of the standards or this section, and may make different provisions for different supply licensees. Any customer who is affected by the failure of a supply licensee to meet a prescribed standard shall be entitled to such compensation as may be determined by or under the published standards. The making of compensation under this section in respect of any failure by a supply licensee to meet a prescribed standard shall not prejudice any other remedy which may be available in respect of the act or omission of the supply licensee which constituted that failure. The office may, after investigation of a complaint from a customer, issue an order or directive requiring a licensee to pay compensation to any person affected by an action or inaction of the licensee in contravention of this act, any regulations made under this act, its license, or any determination, memorandum, order, or directive of the office. So those are the clauses that we are proposing for consideration to kind of amplify the OUR's powers in terms of consumer protection. We have also proposed that provisions be considered to address dispute resolution among industry players. We recognize that where there is conflict between different players in the sector, that can result in disruptions as well. The provisions of the Act do not include any provisions for formal dispute resolution as between industry players, and industry players would include not only current players, but potential, because there may be applicants for licenses who may have issues where disputes arise, because you do recognize, for example, that if a new generation licensee comes into the sector, they will have to negotiate power purchase agreements, etc., with other industry players as well. So conflicts could arise there. In those situations, currently, the OUR is often called upon to resolve these disagreements and disputes. It is proposed, however, that some formalization of this process be contemplated in the legislation. We suggested some language. The office may resolve disputes between licensees and applicants for an electricity license, and in resolving such disputes, make such determination as it considers necessary to protect the interest of consumers and preserve the rights of a licensee. Any dispute, as referenced in subsection 1, may be referred to the office for resolution by either party. The office shall publish the practice and procedure to be followed in connection with the resolution of disputes under this section. A determination made under subsection 1 shall be final and shall be enforceable as if it were a judgment of an appropriate court. And so here we are proposing that a formal process be addressed in the legislation, and that it be clear that how we resolve the dispute, we have the powers of perhaps a statutorily established arbitration tribunal, so that that will incentivize compliance. No questions?
I'm sorry to interrupt you.
Yes.
Minister Chair, unfortunately, I have to deal with some urgent constituency matters. So forgive me, I have to leave early today. But I will also allow you to use my name to sign off on the minutes. The minutes are quite okay. All right. Chairman.
Thank you, Member Paul. Well, I think we're coming up to closing time anyways, 2012. So I think we should be shutting, adjourning
Right.
due course. So I don't think you'll miss much.
All right, and I found the minutes to be in order, so I can second that.
Great. All right. And then the meetings you'll be communicated with in relation to the new dates for January.
All right, thanks very much. Merry Christmas, everybody.
Thanks.
All the best.
See you too.
And Chairman, the final point that we raised on this paper had to do with the regulatory framework for electric vehicle penetration. We know this is a point of, well, it's gone beyond discussion, but actual research into the whole manner in which electric vehicle penetration can be encouraged in Jamaica. We have identified the potential benefits to the Jamaican economy and especially the environment if there is a large-scale adoption of electric vehicles. And some of these benefits include improved energy efficiency and energy security, as well as positive environmental impacts, such as reduction in air and noise pollution. There are, however, some barriers to electric vehicle deployment, which we believe can be overcome by modification of existing legislation. I just pause here to say that we raised this for consideration and to say that it does not necessarily have to be addressed in the Electricity Act, because we recognize that the whole issue of electric vehicles transcend just the electricity sector. It has a much wider impact, and it may be the consideration of the government to consider specific legislation to address this. And so we're not proposing that these should be specifically addressed in the Electricity Act, unless that is the leaning of the government, but these are a few things for consideration. So one of the things has to do with what we perceive to be restrictions on participating in electric vehicle or participation in the electric vehicle charging market. In light of the definition of supply, which we had discussed earlier, there is the likelihood that participation in the electric vehicle charging market will be restricted to the current electricity provider in Jamaica, who holds an exclusive license to supply electricity. And so it is suggested that perhaps the Electricity Act be amended to expressly exclude the activities of electric vehicle charging stations from being considered as supply of electricity. This change would also require related adjustments to exclusivity provisions in the electric license, and therefore that has wider policy implications that the government will have to consider and discuss with relevant stakeholders.
Chairman, my hand is up.
Right, Member Hill.
I agree with this proposal. Already the utility provider has a very privileged position, which was negotiated, and therefore they can't be blamed for it. They didn't give themselves that. It was negotiated by people who had the authority to negotiate with them and give it to them. However, given where electric vehicles are going and that the market is opening, I would want to see that it is not included in the Electricity Act as a privilege of the utility holder, but left open so that private people can come up with really innovative and sensible and competitive suggestions. Maybe not just one supplier, there'll be others, but competition will make sure that we have the right supply and the right approach to it. Now, bearing in mind that it's a new industry, and in fact, Chairman, Minister, the government may have to think of, shall we say, incentivizing, maybe even marking out the roadway and supplying some of the asphalt for the road to make it work, because it's in the national interest to have us supplying energy to electric vehicles, and probably not from fossil fuel. There could be others, fossil fuel could be in, but it would be part of the mix. Everything that I'm trying to see in this Electricity Act is that there must be more and as many as possible suppliers of sources of energy, not just one, not just renewable, because renewable alone can't do it, not just fossil fuel, because fossil fuel is going to dirty up our place, but it's necessary to have. So we have to have a mix. And if you give it to the utility alone, you won't have the kind of broad mixture and competitive mixture that we now do not have in the sources of energy that we use. So we must not go back there. I agree with what is being proposed.
Point well taken, member, and I do agree as well. And I think that is something that we will pursue. I know that the ministry team is on, so we'll note that and definitely pursue it. But I agree wholeheartedly.
And our final point is in recognition that the introduction of electric vehicles will have an impact on the electricity grid. So we have to emphasize the need to ensure that proper technical standards are implemented and legislated. And so the proposal is either in the Electricity Act or in discrete electric vehicle legislation. Provision should be made for the imposition of standards and regulation of interaction between participants in the charging market, including the provision for the development of standards governing the accommodation of different electric vehicle types that may be imported into the country, provision for the imposition of information requirements and technical safety standards to ensure reliability and integrity of the electricity grid where charging stations are connected to the grid, and also provisions for imposition of safeguards to avoid monopolization of the charging market, such as by the current exclusive supplier of electricity. So that's the final point on this paper.
I agree with that, Chairman, with your permission, but I want to broaden it. The same kind of, one of the complaints that we have from various parts of our business in the country, and since we're in electricity, let's look at electricity. The renewable energy people complain that there are no agreed standards in terms of time that must come back. In other words, they want more specific standards. And I think you're on the right track when you're saying before we even install this electricity, this EV charging arrangements, we put in standards with teeth and with responses from different parties to make sure it works efficiently. We don't put it in and then we're going to run after it with regulations and standards and so on. Put in the standards and regulations by which the operators must apply. And we must now move to do that too for the renewable energy. And in fact, when I'm looking at water, I'm going to do the same thing for renewable water. Thank you.
Thank you, member.
So,
looks like we're at the end of our session, Chairman.
Yes, I think based on where we just concluded a while ago, it would be good to allow the staff to get prepared for their next meeting. And I think it will flow smoother in our next meeting. So let me just get so can we—
While you're doing that, Chairman, I'd just like to say thank you to OUR Ms. Janae for outlining as clearly as they've done. And yes, there's a lot for us to think about. Thank you very much.
So we'll have OUR back again. We are proposing dates of Thursday, January 13th at 10 a.m. and Thursday, January 20th at 10 a.m. And hopefully those two dates would be able to, for the OUR to conclude.
Chairman, could you just repeat the first date?
Thursday, January 13th at 10 a.m.
January 13th at 10 a.m.
And Thursday, January 20th at 10 a.m.
Excuse me, Chair,
13th and 20th of January.
Thank you.
Excuse me, Chair. Sorry,
Yeah.
sir. But I think OUR would have completed their recommendations based on what Ms. Riley did, including the general recommendations that they made. So I'm not sure if Ms. Campbell would want to say something now. Because Ms. Riley actually finished quicker than we thought today. So
Okay, so what is it that OUR has left to present?
I think they have completed their part, sir, unless I don't know if you want them to come when the ministry is doing their presentation, but I think OUR has completed their part. So I'm not certain whether the committee would want to, if Ms. Campbell would want to interject here, because we still have general recommendations from other entities that we haven't covered, as well as I think Ms. Campbell had gone up to section 29 before we stopped for the OUR to come to both meetings. But then the ministry is supposed to complete their collaboration with OPC and so on. So I'm not sure where the ministry would come back. At what point, since there's still a lot to be covered.
Chair, is it through you? Do I understand Ms. McCarthy to be saying that if it is the OUR finished today, then we're next going to hear from the ministry?
Well, that's dependent on whether the ministry would be ready on the 13th of January, because remember they had some consultations with the legal reform. Who is here from the ministry?
Dean Campbell is here, Minister.
Ms. Campbell, share some light on this one, please.
Okay, I noticed, good afternoon, Minister, members, and the wider audience. The OUR, I'm not sure if you had dealt with the third schedule, your comment on the third schedule. I think that might be outstanding. And if that could be taken now, then that would conclude the presentation. And then in respect to the ministry's presentation, we would be inclined to recommend the latest date then in January.
The later date, meaning the 20th of January?
Yes, Minister.
Okay, so OUR, are you able to take us through that quickly, or you want to defer that onto the 13th of January?
Let me just, oops. Sorry. Minister, sorry, my video is not working. Can I just confer just 60 seconds with my team?
Sure.
Excuse me, Chair, I think Ms. Eaton from OPC wanted to say something. Ms. Eaton?
Go ahead.
Good afternoon, everyone. Good afternoon. Good afternoon. I just wanted to interject in terms of the setting of timelines. Is it my understanding with the ministry that the presentation that they will be giving in respect of their recommendations, they anticipate that they would like to have the benefit of proposed draft amendments? I just wish to be clear on this because I any engagement with the ministry on that matter in terms of setting timelines. So I just wanted to get a sense of what the committee's expectations are in terms of the presentation by the ministry.
Thank you. Ms. Campbell, you want to respond to that?
I'm sorry, I was speaking, but I didn't realize I was still muted. The ministry, yes, would require the benefit of instructions, the benefit of comments from CPC, OPC in relation to some of the recommendations that are presented.
Well, just for clarification that I'm understanding here is that my understanding was that I would be preparing proposals in terms of draft text based on the recommendations to be made and to be accepted. So if it is that in terms of making a contribution to the ministry's presentation on the recommendations in terms of what the ministry itself is recommending, if there is to be language drafted demonstrating those recommendations, then I would need to have the benefit of those proposals so that I can prepare the relevant amendments for consideration by the committee. Now, the ministry, so in setting timelines, whereas your timelines may contemplate your assessment of what you intend to present, I mean, I would like to be engaged so that I can have an idea in order to prepare the language that you wish to complement or to be presented along with your recommendations for consideration by the committee.
Mr. Chairman, if I might, because I'm hearing Ms. Eaton, so I agree with Ms. Eaton that we definitely have to contemplate the drafting exercise that would accompany that. But I'm not so sure that the two need to go with each other, because my recollection is we had a number of concerns in terms of clarity of policy, policy positions that we needed to look at and have explained to us in relation to the comments that came up on the various provisions. I imagine the ministry has noted those, and I would think those would require the committee's further deliberations prior to coming to a position in relation to amendments to be proposed. I think maybe the two don't go together at this point.
If I may respond, yes, so the full instructions would follow the accepted recommendations from the committee, but there are other elements that we may require the Office of the Parliamentary Counsel to opine on whether or not the recommendations would require redrafting or any other alternative that might be better to address the particular provision. So in respect of, I take a point, but I believe that in terms of minor issues that can be dealt with prior to the recommendations being accepted, then we might need to refer to OPC on that. And I don't think that it could necessarily affect the presentation, but I do accept that there is need to present those to OPC ahead of time so that.
If I might again, I know that, you know, coming up after the Christmas holidays in January and the end of the legislative year staring us down the barrel, I know how you would want us to advance the work of the committee to get to some sort of stage where we can talk about concluding. January being January, February, a short month, and then there is March. We're already talking about the 13th and the 20th. Can I propose that the ministry, since we have those 2 dates back to back, that the ministry begin the policy clarity presentation on the 13th, and then if there is a need for amendments that are relevant to that those be taken on the 20th so that OPC has sufficient time, assuming that they would have had the benefit from January to take a look at it at least.
Ms. Campbell?
Minister, I believe January 13 would be a little early for us, and we would prefer the 20th.
All right. All right, OUR?
Yeah. Yes, Chairman. We're requesting to defer our discussion on the right of first refusal. That's the Schedule 3 until January 13.
Okay, so we'll keep those 2 dates, January 13th at 10 a.m. and January 20th at 10 a.m. as well, based on what they just discussed between the ministry and yourselves, and of course, the OPC. So,
Chair, is it also that would OUR be prepared to have further discussions with us on the 13th as well in relation to some of the matters that arose today that you wanted a little more time to think about? Would you also be thinking those?
Yes.
Grateful.
Yes.
Yes. Thank you.
So they will give clarifications on the issues that they asked to be deferred, and also they can complete their presentation. All right, so can I ask for the minutes, confirmation of the minutes of October 28th and November 1st? I know Member Paulwell said he would.
I so moved, Chair.
Yeah, so Member William Campbell moved to confirm the minutes of October 28th, 2021 and November 11th, 2021. Member Paulwell seconded. Okay. With that, is there anything under any other business? Okay, so move for the adjournment, and we will see you on January 13th, 2022 at 10 a.m. Let me take this opportunity to wish you a peaceful and restful Christmas, and most importantly, safe, and of course, all the best for the new year 2022, and hope that obviously we will be moving to normalcy from this pandemic that has plagued us for the better part of 2 years. Until then, everybody stay safe and please enjoy your Christmas. Thank you.
Thank you, Chair, and the very same to you and to the members.
Thank you.
Same to you.
Thanks all.
Thank you all.